Any mention?
May please, Your Lordship, I beg to mention item 17.
Item
17.
70
17.
17. What's 77?
I'm praying that this matter may come after 2 weeks.
Why?
And the senior conducting counsel is on sanction leave.
Mr. Chareso,
No objection, Your Lordship.
is it not anything remains this matter? Anyway,
Hearing is there. Have to take.
after the other judgment was there.
Yes. Let it be formally concluded.
Yes, 3 weeks. Okay.
Highly obliged.
Yes.
Much obliged, Your Lordship.
May please, my lord. My lord, I beg to mention item number 16.
16.
16, my lord, yes. I presume matter will come after 2 weeks, my lord.
What happened with Dindo? It's not well.
He's not keeping well, my lord. He's not keeping well.
He's in hospital or at home.
Now he's at home, my lord. He's currently been advised to take rest.
What happened? He's got diabetes. Oh, what?
Probably diabetes and all.
Okay, 2 weeks. Yes.
No, it's similar play for item number 23.
You're for item number?
16.
16.
Okay. 2 weeks, yes.
Similar for item number 23 as well, my lord.
22?
23.
Yeah, 23.
My lord.
As the senior counsels is still be indisposed. Yes.
May it please, Your Lordship. Your Lordship, I beg to mention item number 20, Your Lordship. The conducting counsel for the state, Ms. N.G. Shalla, is not available today, Your Lordship.
After 1 week, yes.
Obliged, Your Lordship. Daily list, item number 1.
Yes, Mr. Chanda.
Item 12. Today, because of the puja, I could not come. It may come after 2 weeks, my lord.
12 is
It's connected with 11 to 15 minutes.
connected with
11 to 15 minutes.
12 was the Pathak.
After 2 weeks, my lord.
The Pathak. Puja today or today Saraswati Puja is, no?
My lord, today is puja, my lord.
But today is a holiday in Guwahati.
Yes, it's a holiday.
Yes, my lord, holiday.
Today is
Yes, today is a holiday. You know, something else is there.
Saraswati Puja.
Okay, 11 to 15 after 2 weeks is
Obliged,
request
sir. Deeply
counsel-
obliged.
the counsel for the petitioners.
Deeply obliged.
Yes.
Deeply obliged.
Daily list, item number 1.
This matter, my lord, we had prayed for release of our security deposit and
Where's
the pending bill.
your opponent?
Miss R.
Get
Kohli,
her.
and she was supposed to take instructions.
Yes.
But, will it come at the end of the board? My lord?
Yes.
Item number 2.
My lord, this matter.
I think another counsel is appearing in this case
I'm
for the
sorry.
petition. Another counsel is appearing in this case for the petitioner.
On the last occasions, my lord,
He undertook to, he said, I'm preparing the matter to argue on the next date.
I don't know.
No,
If
you
then,
are not
then we
here.
can-
He said he came after the loan. He said, I'm just preparing the matter. I'm arguing it. I'm going to argue it on the next date. That's what he told the court. So I don't know.
we can-
Okay, start.
My lord, here we are aggrieved. We are a village, my lord. We are a village. Our village name is Laitsoum, and we are of around 800 members of the village, my lord.
800.
Now, 800 members of the village, my lord. Here we are aggrieved because we have been deprived of drinking water, my lord. Now the problem is, my lord, there was including this with the same issue. This is the third writ petition. Of course, the first writ petition, my lord, was dismissed on being default. Thereafter, another writ petition was filed, and the writ petition was disposed of with with liberty to us to go and approach by way of representation to the PHE. Now the private respondents have objected. The other village has objected. Panputblay village. They have objected, my lord.
Okay, now you're not getting water, you saying?
We are not getting water.
So
my
where
lord.
do you draw? Where's your normal source of water?
Now there is no source of water.
It belongs to you, the source.
My lord, that source.
Within your village jurisdiction.
My lord, that is, my lord, it has been admitted also, my lord, this is the only source within these ilakas, my lord, in the Simshi, all the villagers are sharing the same source, my lord.
Okay.
That is dispute under which village jurisdiction it lies, but there is since time immemorial, all the villagers surrounding have been equally sharing this source, my lord. This is the only source of water available. Now at this time, my lord, during winters, my village, we are walking down the valley, my lord, only 3 kilometers to fetch water, my lord. And that also is not a very healthy water, my lord. And we have been deprived this initially 2013, then after that intervention, okay, 2019 again, now 2020, since 2020.
Now who's depriving you?
Depriving, my lord, number one thing, my lord, the respondents, the other respondents, the other village, they are depriving, number one. Number two, my lord, now it is a responsibility of the state.
Whatever it is. So why, if you're drawing water from there, why should it stop now?
My lord, because they have destroyed the pipe that is connecting to our village.
The pipe?
The private respondents, my lord. The respondent number 5. FIRs have been filed. FIR has been filed, my lord.
Who's the private respondent who destroyed your pipe? That is the scheme of Musunram.
No, it is a headman of Panputblay and the secretary.
Panblay or Panputblay?
Putblay. Putpanblay. My lord is very much. My lord is aware that in the Narmada Bachao Andolan's case, report in 2000, volume 10, SEC 664, it says that the water. I'll just read that paragraph, my lord. Water is the basic need for the survival of human beings.
Forget about the judgment right now. What is your grievance now? You're saying that you are being stopped from drawing water, or your pipe's been destroyed by
yes.
Number 5?
Yes.
Since when?
Since 2020, Lordship. Because
have you taken up the matter with the PHE?
Who
installed the pipes?
We have, my lord. We have by filing representations, my lord.
Who installed the pipes? Who laid on the pipes?
A PHE, my lord, under the drinking water scheme.
Responsibility to maintain the pipes and see that everyone gets water.
Yes, exactly. That is.
Don't cover the Jal Jeevan Mission.
My lord, Jal Jeevan Mission has not yet come, my lord. Now the private respondents are denying even the PHE to maintain, and PHE is sitting over, my lord.
How can that be possible?
That is possible. That's why we are not getting the water. That is not possible, my lord. But they are doing it by forcefully. That's why we had to come before my lords for a direction, my lord.
Very strange.
Yes, my lord. Because water, my lord, we are not.
No, forget about that. I mean, if you've been drawing water from there, what is the cause of dispute?
No, the cause of dispute is like this, my lord.
Is it territorial?
It is territorial, is there? But the issue.
What is the dispute between you and this Putpanblay within your village? That's a woman Putpanblay. What's the dispute?
The Putpanblay, what happened was, my lord, there was a scheme. The water scheme has come. Earlier there was a scheme, but a bigger scheme has come. So the village, my village got that scheme, and we wanted to connect the water to our village. Now the allegation by the other side is that this source of water needs to be shared by everybody. How can you just divert entire water to your village alone? So that was a dispute, but that is actually not a fact. That's not a fact. There's a scheme for connection of water to my village. That scheme was being implemented.
No, that means that you took the entire water, and
that is the allegation. That is their allegation, which is not correct. No, they had the basic thing is, lordship.
And so you mean to say that the PHE implemented a scheme and exclusively drew water from there only for your village?
No, because this is a water connection, my lord.
No,
maybe the pipes are.
I'm just trying to understand.
Yes.
That means a scheme was got by your village.
Yes.
And so the water was drawn there, and the PHE executed the project and the water was excessively drawn, did they make pipes to other villages also?
That, my
So
lord,
did they make pipes to other villages also from the same source?
no, the pipes are not made to the other villages. The
That's
pipes
the reason.
Yes. But my
If
lord,
you say that since time memorial you've been sharing this water source equally, now also if you have pipes, you should share it equally.
now, my lord, sharing
That
equally.
means that time when
Yes.
the pipes installed, you didn't share it with them anymore.
No, it's not a fact, my lord. They have their own source. The pipes going to their own sources. That
Where
is
from
there.
is-
That is not my scheme. The pipe that is been newly installed, that is not disturbing the distribution of water to their villages.
But is it decreasing the supply to them?
Maybe, but that is not good enough to destroy my pipe. And then the PHE is responsibility cast upon them. So now, my lord, for many years we are without water.
Yes, Mr. Sinkan. Many years of water have come when? When was the pipe destroyed?
2020,
My lord,
yes, sir.
2013 started, but then as and when the court intervened.
No. Then
Yes. Now
2013,
2020.
The scheme was from 2013.
Now
Now what?
now is 2020, my lord.
They destroyed
2019,
2020.
yes, my lord.
19. What are you doing for 4 years?
My lord, there was a lot of representation also,
What are
and
you
then
doing for 4 years? You had no water for 4 years.
there was no water, my lord.
4
And
years
then,
had no water.
We have been approaching the PHE every now and then, my lord.
Sounds
When
very
everything
strange.
has failed, then only we have come,
There's
my
more
lord.
than that meets the eye, maybe. Where's the
My lord may see my representation at.
We have to see whether this source is maintained by the PHE or not. This may be a
No,
private
not
source.
that, Mr. Sinkan. The thing is that
80
they come to court before,
Yes.
and the grievance petition is present. You are the petitioner then.
My lord, my lord.
This order is there, page 68. The grievance petition is present. The petition, demolition of water tank.
Water tank.
Now again water tank.
Water tank, my lord.
Again.
Again,
It was
my-
reconstructed.
Reconstructed after that, my lord, with interventions of PHE and all this. But again, my lord, now, my lord, page 87, this is our last representation, my lord. Page 87 is last representation. But in between, my lord, of course, there was no written representation, but the approach has been made every now and then, my lord.
Okay. Okay, now we get it. This is a reply to the. It's an old reply, but yes. I get what is the problem. We get what's the problem. You share equally, Mr. Yubin.
My lord?
Share equally. Because as per what the materials you annexed to me, is that your
My pipe.
your village
Yes.
doesn't come with Mosram's imship also.
It doesn't come, my
It
lord.
is null-wise that ship, right?
Yes, yes,
But
my lord.
even then, these people of this your respondent village, they're allowed, since the only source allowed you to use the source of
Yes,
water.
yes.
But as you're more dominant and larger in population, you have installed pumps and depriving the other villages. So the only thing that these people are concerned that they have no quarrel with sharing water. Only that do not dominate and do not, use water only for yourself, depriving the other villages of Mausandam's imship.
This is what they
That's
said
the
in
only
their
thing.
objection, my lord.
Exactly, if that's the objection, and then they're saying that we have no quarrel with you, and since we're willing to share, but at least share equally, and just because you're a larger population doesn't mean that you install pumps and divert the entire water to your village only. So who's at fault here?
My lord, by reading the objection raised by the respondent, it would seem that it is our fault, my lord.
And even then, you must remember one thing.
Yes.
Whatever it is that water source doesn't fall within your Sardarship. It comes within Mausandam's imship. But the thing is that because there's no other source, they allowed also for you to draw water from there.
My lord.
But allowing to draw water doesn't mean that you usurp the entire source and to the exclusion of others.
My lord, and that what they have alleged here, my lord.
Anyway,
that,
yes, 4 years you go on without water. I think it can go another 2 weeks without water.
My
if
lord.
you see any water.
My lord.
No, but there has to be something. That is why.
There has to be some act.
No, the thing is that it's your village which is, using muscle power to, to deprive, because you're a bigger village, you have more population. That is why these other smaller villages around are getting deprived.
My lord,
Anyway,
that is not.
Mr. P. Owen,
Yes.
issue notice. Mr. Ensign Khan is present, accept notice on behalf of respondents. Respondents number?
1 to 3, my
Be
lord.
alive, huh? 1 to 3. Notice to be issued to respondent 4 and 5 within 3 days. This also 3 weeks for instructions. You see how you can resolve it?
My lord,
It's
my
further provided that the state respondent shall try to resolve the dispute with regard to sharing the water equally, so as no village should be deprived which have been using this water for their drinking purposes, drinking other purposes. Yes.
Obliged.
Supplementary list item number 1.
Yes.
Wait, please, Your Lordship. Your Lordship, this is a contempt petition, Your Lordship. Your Lordship has passed an order for the demarcation of the petitioner's acre, Your
Where's,
Lordship.
okay, issue notice. Where's Mr. Deb can accept notice to cut short the holes. Just get him.
Yes, Your Lordship.
If nothing is only for demarcation.
Yes, Your
They said to
Lordship.
do it within?
Within
Court said
45
within?
days, Your Lordship. 45 days. But 5 months have lapsed, Your Lordship. They haven't complied with the order.
Where's the order?
It's page 10, annexure 2, Your Lordship.
This is submission that will be completed,
Yes, Your
not a
Lordship.
court direction. Can you call him? Yes. Another matter first.
Item number 2.
Yes, please, Shilawat.
Please, Lordship. Lordship, this is a second round litigation, Lordship. The issue here is with regard to the unilateral action of the respondent district council in including the locality of our village into the boundaries of another village, Lordship. Lordship, on 15/6/2022, we have filed a writ before this honourable court.
15/6/2022.
We have filed a writ before this honourable court. We have challenged the notification issued by the respondent district council, by which they have included our locality into another village. During the pendency of that writ petition, the respondent district council, they filed their affidavit in opposition, my lord, and they have brought under court certain orders which they have claimed to have passed prior to the issuance of the notification. So accordingly, because that order was not challenged, we withdrew our writ petition with the liberty of challenging it.
You're not aware of this?
No.
Since when we are aware that the locality had been taken away from your village?
We were aware that the locality was included through a notification.
Which you believe is part of your village?
Yes.
The residents of that locality, they are agreeable to be part with the other village?
That's what they have claimed.
Claim means?
Through their order, they have said that, my lord, it seems there was some resolution passed by that locality that they wanted to be
You
with
are opposed
another
to
village.
that?
Yes.
Why are you opposed to that?
Because this is a part of our
Whatever it
boundaries.
is, suppose they don't want to be with you
No,
anymore.
because this factually that is also incorrect, my lord.
You have a darbar to decide whether they want to go out or stay in.
you know, because if this is allowed, it will set a wrong precedent, my lord.
What
Now,
wrong precedent?
because
it happens
now
all
every
the time,
local-
increasing and decreasing the area of the villages. It happens all the time.
Because-
suppose sometime in the locality the headman's inimical towards them, they said, okay, fine, not getting the schemes, not getting anything, and it was a little bit
No,
far-flung.
that is a different issue, my lord.
What is the consideration here? Why was it put with the other village?
Because the other, according to them, this particular locality wanted to be, but they have never explained the reason, Your Lordship.
How is that possible? Then on what consideration was the notification passed?
Lordship,
What's the reasoning?
the notification is at page 22, Lordship.
20?
21, Your Lordship. This is
No,
notified.
on what basis was this issued?
This is to notify that the
No, okay, the notification fine. What is Annexure 10?
Annexure 10 is the order, sorry, page 60.
That is what, on being heard from the party, statement given by them, documents filed records in that Madan Kha have unanimously agreed to join and entered with Sokan Forneng as a part of it. That's all.
That's all.
What is this? You take instructions. Heard Mr. J. Shilla, Learned Counsel, the petitioner issue notice. Dr. N. Mozika,
1 to 5.
from Thao, is present and accept on behalf of respondents 1 to 5. Prejudice steps issues notice on respondents 6 or 7 within 3 days. This after 3 weeks for affidavit instructions. So there has to be some reasoning. There's a process also. They have the consent will be taken majority of the parent village. You can't just cut it away and put it in another place. Yes.
Item number 3.
Customary law is that.
Yes, yes. Obliged.
Yes.
Your Lordship, the petitioner here is before Your Lordship with a prayer for reinstatement in service.
Reinstatement? How old
Yes,
is he now?
reinstatement. He was terminated on 7/8/2015.
15?
Premature retirement, yes. Your Lordship, after that, the petitioner has filed a writ petition before the Honourable High Court, bearing number WPC number 269. And by common judgment order dated 15/3 passed in WPC 12 of 2015, along with 59 other connected writ petitions, the Honourable Single Judge had dismissed the writ petition, including the writ petition of the petitioner.
Then what happened? He filed appeal.
But in some similar matters,
Would you file appeal against the order?
yes,
You filed.
there was a writ appeal number 407/2016, which
That was
was
dismissed.
dismissed.
Then you went to Supreme Court.
Yes, and
Then what happened to
SLP
Supreme Court?
has dismissed the
SLP dismissed also.
Yes.
What do you want now?
There was this reinstatement of the others similarly situated colleagues of the petitioner who were reinstated. Right order 31/8 of 2022 passed in WPC number 62/2015. But since the
By which
petitioner
court? By this court?
by the Court of Justice.
Okay,
Ringdor.
anyway, were you asking for what
Other
treatment?
similar matters is still pending before Your Lordship.
Yes, Mr. Dr. Mozika?
But identical matters are pending, my lord. But here they were not the party in the writ appeal that was filed before. They filed the writ petition, my lord. Once the writ petition was dismissed, my lord,
They kept quiet.
they kept quiet. Others, they came and filed writ appeal, my lord. And the writ appeal, the division bench granted relief only qua the petitioners, my lord. Qua the appellants, my lord.
What about the rest?
Because rest, in my humble submission, is a res judicata, my lord. The DB order is very specific that only qua the petitioners, qua the appellants, writ petitions will restored.
Issue notice.
My lord.
I had MS Eastern Democratic Council Petitioner. She noted Dr. Mozika also accept photos on behalf of all the respondents. No photos, no photos required. This matter of 3 weeks for instructions, I believe.
Item number 4.
Well, I have sent the notice on 5th February.
No, it's number 4. What's this? Which list is this?
Supplement.
Oh, I'm sorry.
Yes.
Your Lordship, we have taken instructions. 8 and 14 are the same person.
Same person. Okay, then we strike off number 14.
Lordship.
And we will, first in the main case. In the main case, MS B. Kawan Lang, the Council petition submits that due to inadvertence in the array of parties, the respondent number
14. 8 and 14.
8 and 14 are one and the same person. As such, he prays that one of number 14 be struck off from array of parties. Prayers allowed. Number 14 struck off from the array of parties. Now, Miss Case. Miss Case number separate order 23. No objection to this.
No objection, Your Lordship.
Okay. 20. Miss Case number 2324 and WC number 26. This is an application for the. Who's he actually?
Look, this Shahnaz Abbas was brought in, Malaj, as a member subsequently by the subsequent notification, Malaj.
Okay.
The original notification had mentioned the name of Roshan Ara Begum twice.
Yes, yes.
That's where the confusion arose, Malaj.
Yeah, this application was filed for impleading Port MS Shahnaz Abbas as a party respondent. They submitted that the implement is necessary as MS Shahnaz Abbas has been included. He is a member of the Waqf board now.
Balance.
As you put as a member of our board by subsequent notification. MS Vijayawala appearing for the respondents in the minute petition has no objection. Accordingly, Ms. K is allowed, and MS also with address also is impleaded as party respondent number 14. Number 14 in the instant in the connected writ petition. Stop. Next, in the main case, in view of order passed and so on today, dated so and so and so and so, so and so is added as party is for number 14, registry to make the necessary correction in the court title.
We'll take steps, Malaj.
The steps will be taken by the petitioner within 3 days.
Obliged.
Much obliged, Lordship.
Daily list, item number 3.
SGF Enterprise.
Please, Milord. Look, this is a delay application, Milord, of 823 days.
Yes. 823 days was the matrimonial dispute.
Yes, Milord. What had happened, Milord, I'll just take your lordships. Para 3 onwards, I've made a Milord table of list of dates of what transpired. Now, I'll take your lordships to page 9, an extra 1.
We are convicted for what?
Milord, 307, Milord.
Trying to burn me alive. I'm the wife.
So, an extra 1, Milord, page 9 is the judgment. And your lordships may...
So which court?
Milord, this is a...
Gurgaon?
Yes, Milord, Gurugram, Milord.
Yes.
So, Milord, this ends at page Page 52, my lord, judgment ends. And page 50, at para 88, your lordship will see the punishment. Page 50, 88. Before that, my lord, I'll just indicate that this order was dated 14th of September 2018, and the quantum of sentence was pronounced on 17th of September 2018.
5 years.
Yes, my lord, 5 years. Thereafter, my lord, I was taken into custody.
Yes.
And a divorce petition was filed by the wife, by my learned friend, before the court of the Additional Deputy Commissioner at page 53.
Why did it come from Gurgaon to Shillong? Clear here, I mean.
That is also, my lord, questionable.
My father was working with a Star Cement, my lord, and after that I had no place to come, so I had to shift to with my father.
Okay.
So, my lord, page 53 is the judgment, ex parte judgment passed by the trial court, my lord, the family, the matrimonial court, my lord, family court. This is dated 16th of April 2019.
16th of May.
Oh, sorry, my lord. Date of hearing is 16th of April and 16th of May is the date of judgment. So this was passed ex parte, my lord. I did not receive any notice, and moreover, I was in jail, my lord, at that point in time.
But you said you were convicted on 18, so you were released on 2004.
My lord, I was convicted in 2018.
2003 you were released from prison. Or was there some remission?
Some revision. I was almost 2.5 years. I was in custody, my lord. And
there was remission.
Yes, my lord. The appeal is pending before the Punjab and Haryana High Court. So thereafter, I am on bail, my lord.
You're on bail till now?
Yes, my lord. The appeal is still going on.
Okay.
So 2018 onwards, I was in jail, my lord. So May 2019. My lord.
What is your occupation?
My lord, I'm into physical education. I'm a PhD holder, my lord. In physical education, I'm a coach, my lord. Cricket coach, something like that. At that point in time, my lord. But I lost my job after I was convicted. So, my lord, after this ex parte judgment was passed in May 2019, thereafter, in May 2019 itself, a review was filed at page 56 by my learned friend.
Review for?
To review the ex parte judgment for enhancement of the...
Okay. Then what happened?
Now, just before that, my lord, if I take back your lordships to page 55, last paragraph.
Yes.
Last paragraph at page 55. So the ex parte decree says, my lord, judgment says, since the matter has proceeded ex parte, and the...
Where's that, 55?
Page 55, my lord.
Lecture 3?
Yes, my lord. I did not point this out. So the ex parte judgment was, my lord, since the matter has proceeded ex parte, and the petitioner has prima facie proved her case for dissolution of her marriage.
Where are you reading from?
My lord, page 55, annexure 2. I'm just going back to annexure 2, last page, page 55.
55 is annexure 3.
Your paging is mistake. 55 is annexure 3.
Then, my lord, kindly have 54, my lord.
Okay.
Last paragraph.
Yes.
Since the matter has proceeded ex parte and the petitioner has prima facie proved her case for dissolution of a marriage with the respondent under section 13 of Hindu Marriage Act, I hereby dissolve the marriage of the petitioner with the respondent under section 13, which was solemnized on so-and-so. In dissolution of the said marriage, the respondent is directed to pay a one-time permanent alimony of 15 lakhs to the petitioner within 1 month from the date of this order.
Okay.
So, my lord, immediately thereafter, during the same month, May 2019, at the next page, my lord, next page,
yes.
Page 55, a review was filed by the
Yes.
wife itself.
Yes.
And kindly have page 59, my lords, of the review, last paragraph, paragraph 9.
Yes.
Now, an admission is made in this paragraph 9 that the petitioner begs to state that due to bona fide mistake, the address of the respondent has been wrongly stated in the previous divorce suit number so-and-so, also reflected in the order dated so-and-so as so-and-so, and hence the instant review petition. So,
Okay.
there's an admission that the address was wrong. So, therefore, I did not receive any notice.
No, Okay, okay. Right.
That's why it was ex parte.
So it says RZ29, Anup Nagar, Uttam Nagar, New Delhi. It
Yes.
says RZA49. Okay, only the numbers different.
Yes, ma'am.
A49.
So RZ29 and RZA49.
So what happened was notice issued again with regard with the judgment was served on the on you after that.
No,
after
ma'am.
the correct address
So,
was
so what the court did was issued notice in the review to me in the correct address.
Okay, then what happened?
I received the notice, my lord. I then, my lord, appeared before the honorable court, my lord. At page 65, page 63 is a type copy. Notice was issued, my lord, on 29/7/2019. And your lordship, page 65, order dated 30th of August 2019. This is when I entered appearance.
39. That is on 30th of August.
August 2019. Seen the affidavit bringing on record the service of notice served upon the respondent along with postal so-and-so. Learned counsel so-and-so filed hazira and executed wakalatnama on behalf of the respondent, Shri Rohit Kalia.
So what happened after this?
After this, my lord, what happened was, since I was in
jail.
custody, my lord, in jail, so we sought permission, we filed an application seeking permission from the Honorable Court to direct the said superintendent, my lord, to kindly allow me to sign the affidavit and he should countersign it. So that process went on, and my lord, we also filed an application for recalling the judgment in view of the same being passed ex parte without me being served. So, my lord, next page, page 67.
Yes.
26/11/2019.
Yes.
So, notice was issued, my lord. Seen hazira filed by so and so. The orders of parties absent without steps. Seen and perusal the perusal. They should be perused. Seen and perused the petition date petition 26/11/2019. That is ours. On perusal of the same, the petitioner prays before this court to issue notice to the opposite party petitioner, calling upon them to show cause as to why the ex parte judgment and orders so and so may be kept in abeyance. Also seen and perused the petition number so and so filed by the counsel Mr. so and so, the respondent praying before this to direct the Superintendent District Jail, Gurugram, to sign the affidavit. So, my lord, I did file an application, my lord, for recalling. This was 2019, my lord.
This is type of, let's see. Right?
Original copy, my lord. Original is at page 66.
Okay. Yes.
So 2019, my lord, then it went on. By the time it was taking time for the affidavit to come and all that, my lord. Now, in between, my lord, last hearing happened at page 69.
What happened then after? What happened to that judgment? Was it recalled?
No, my lord.
Then,
my lord, COVID came in between.
Yes.
So last date was 28 February 2020. COVID came in between, matter was not taken up. Then finally, at page 70, Annex 9, this is in March 22.
Yes.
Now these are the proceedings, my lord. Now one interesting point, interesting development happened in between during COVID in 2021 is, my lord, the wife remarried.
Okay.
She remarried because the ex parte order was not recalled as yet. So, my lord, steps were being taken, and then I got to know that she has remarried.
I mean, the hearing for recall was still not done.
Not done, my lord. Not done because of certain defects or for many reasons, my lord. And in between, my lord, then the review also got dismissed on merits, filed by my learned friend. So that got dismissed.
Review is only for correction of the address?
No, my lord. Review is for enhancement of the 15 lakhs. But they admitted there that the address in the divorce suit was wrong.
Okay.
So, my lord, the review got dismissed on merits, disposed of, my lord, on merits, and we were to take steps regarding certain corrections in the application or something. Now, during that period, my lord, then we got to know that she remarried. Now, the remarriage certificate is there in my first appeal, my lord. I have not annexed it here.
Okay.
So then we had to take a fresh call, my lord, as to how should we go about this entire issue, because recalling the order would amount to the subsequent marriage being void, because she's already remarried. So we had to take a decision on how to go about it. So we decided...
Because marriage was dissolved by the early order, which is Sikh.
Yes, dissolved. So she remarried rightfully, my lord. But if the judgment is recalled, then we'll be in a very peculiar situation where a person who has subsequently remarried. So we decided, my lord, that we will, my lord, partly challenge the judgment before this honourable court and not pursue with the...
Only ground of maintenance on the
only
one
on
time
the
alimony.
only on the 15 lakhs, my lord. Because after I was convicted, I was without a job, my lord. And after I'm on bail, I'm just doing some part-time jobs, my lord, just to survive. My family has also disowned me, my lord. My father, my brothers.
Naturally, you try to burn your wife.
My lord, they were also accused.
Okay.
They were also accused, but they have been acquitted.
That's the point, yes. Then
Yes,
what
my
happened?
So therefore, my lord, this delay before your lordship, my lord, to come before your lordships.
No, 22, then okay, from 19 to 22,
Yes.
that's right.
So
yes, Mr.
My lord, the fact that they said that they did not know about the order, that is essentially is not correct, my lord. And my lord, for that, very quickly I'll take to the judgment pass in the divorce petition, page 52, my lord. As a page 52. Page 52 of my friend's condonation application, my lord. May I just read the first paragraph, that a petitioner in this instant case had preferred a petition under section 13 of the Hindu Marriage Act for grant of a decree of divorce to dissolve the marriage of the petitioner with the respondent according to Hindu customs on 12 February 2016. The petition was registered as Met Divorce Suit number 3 of 2018, and the notice was issued to the respondent. The respondent, after receiving the notice, what was the evidence before the court to say that after receiving the notice? He must have received the notice. That is why the court has come to this finding. Now, in my review petitions, what I said, it's immaterial. Because
material, how received notice wrong address then?
My lord,
you went to jail.
My lord could have been in jail. Therefore, they said this my lord to
then
be
the cause of
effectively
this
served.
divorce suit. We'll call for them then.
My lord, and also my lord, second objections that I wanted to take also, my lord. Now, my lord, this is this applications is nothing but to further mentally harass me, my lord. Number one thing, they try to burn me alive, my lord. I suffer 30 to 40 burnt injuries, my lord, and because of which he got convicted. And my lord, after that, my lord, he filed an application. He filed a petition before the Punjab and Haryana court, my lord.
For what?
For setting for suspension of the remaining period of his conviction, because it was passed by the Gurugram's trial court, my lord. And my lord, in that he says that I wanted to compromise. So the court has issued summon to me, and I appeared personally before the court of the Punjab and Haryana also, my lord. And I said that I don't want to compromise.
Compromise on what? If there's the offence is 07, what's the question of
my lord,
then?
Exactly, my lord. I was summoned, my lord. I was summoned.
How is that possible?
My lord, kindly look at my paragraph 9, my lord, and the order of my objection, my lord. Here the objection order, my lord, which I have attached here at page 11 of my counter, my lord. May I just read? Rohit Kalia versus, this is downloaded, my lord.
Page?
Page 11, my lord, annexure 1 of my objection. Of the objection, my lord. Prayer, my lord, may I read? Prayer in the present in for suspension of remaining sentence for applicant Rohit Kalia, who has been convicted and sentenced to 5 years rigorous imprisonment for an offence under section 307 IPC for having tried to kill his wife Meenakshi by pouring a chemical and set her alight, for exploring the possibility of amicable settlement in view of the divorce proceedings initiated by the wife.
Oh, the divorce proceedings comprise.
Yes.
Okay.
Complainant on the ground of cruelty. The complainant wife had been directed to present in the court. The complainant along with her counsel is present in the court and has been outrightly rejected any effort for settlement in view of the divorce proceedings having already been granted in her favor. At this stage, the London State Council submits that the appellant is yet to undergo 1.5 years of awarded sentence. One third of the awarded sentence. So this order was passed on 19/11/2019. So now he cannot say that he did not know the order of the divorce petition, my lord. Therefore, my lord, now that is one thing. Second thing is, my lord, now they have come before this honorable court by representing by misrepresenting the facts also. The registry itself, my lord, this court's registry itself have said, and my lords have also noted it down, that there is a delay of 1,012 days.
Yes.
My lord, can you look at my para 5 of page 7 or page number 3? The said misleading facts that the application deserves to be rejected inasmuch as the application for condemnation of delay itself contains misleading facts.
Which page reading?
Page number 3, my lord, of my of paragraph number 5, my lord. That the my lord has got.
Yes.
That the application deserves to be rejected inasmuch as the application for condonation of delay itself contains
material.
Yes. Now,
but how many days in total that means? We'll go by registry noting.
Yes, my lord. So that means now 689 days they are not able to explain. That's good 2 years. Order dated 9/10/2023, my lord, of my lord.
9/10?
9/10/2023, my lord.
Okay. 150 days. Why this is only 823 days?
But the COVID period has to be excluded in terms of the Supreme Court's judgments or orders.
And thirdly also, my lord.
Even then 823 days is a long time. And how do you say, Mr. Normally they are not aware of the proceedings when he went before the Punjab High Court saying that the marriage been dissolved.
My lord,
and that happened in November 19. That means that actually your bona fides are in question.
No, my lord. Kindly have page 65 again. I pointed out to your lordships that in August 2019, I entered appearance. August 2019.
After being reserved?
Yes, in the review. What my learned friend is showing is November 2019. In November 2019, I knew, my lord, because I entered appearance in August 2019.
You had already been served on?
Page 65, 30th of August 2019, I entered appearance, my lord. My learned friend is talking about November 2019.
Okay.
So
you were served on?
I was served, my lord. Around this period, I was served. And I entered appearance in August 2019. Because it says, my lord, the order reads, my lord, seen the affidavit to bring on record the service of notice served upon respondent.
Well, why do you file in Punjab High Court then?
That's the High Court within which jurisdiction Gurugram comes, my lord.
No, but if the divorce had been granted by Clariat?
My lord, this is a criminal appeal, my lord.
Before Punjab High Court?
Yes, my lord.
Okay.
I was convicted by the trial court of Gurugram, my lord.
Yes.
Appeal lies before that court, my lord.
Very confusing case, because now in that petition of Gurugram is saying that, before Payahari he said that for the dissolution of marriage or for the reconciliation or something like that. Yes. Orders 1711.
Yes,
1911.
1911.
Okay. 1911-19.
Yes.
And
page 65, my lord, I entered appearance in August.
Now, what about the finding of this Clariat court that petition registered, was issued response for after received notice and appear for this court?
There must be some material before the court.
The first paragraph is Annexure 2 of your appeal memo. And the second paragraph was noted very categorically.
Yes.
Unless it's contrived receipt. We have to call for the records of this one.
Yes, my lord.
Before we decide condemnation.
My lord. Yes, my lord.
Yes, heard Mr. Philemon Nongbudi, learned counsel with the appellant as well as the applicant, this case number 21, as well as Mr. P. Ubin, who has filed objection to the condemnation application. Stop. The ground as set forth, next paragraph, by the appellant is that they were not received of any notice about the proceedings of MAT divorce suit number 3018, and were not aware when the order dated, when judgment dated 16th May 2019 was passed, whereby the marriage stood dissolved and the appellant herein directed to pay a one-time permanent alimony of rupees 15 lakhs to the petitioner. Stop. It has been further submitted that it was only after review application had been filed by the respondent stroke opposite party that the appellant was aware about proceedings and entered appearance on August 2019. Stop. Next paragraph. A perusal of the judgment and order dated 16 May 2019, however, in the first two paragraphs, reflect that the appellant had been served with the notice and had not appeared in spite of the service. In this view of the matter, the records of MAT divorce suit number 3018 need to be requisitioned for a final adjudication of the condemnation application. Accordingly, call for the records of so-and-so from the court of the. Whether they'll still have the records there, or they'll have it.
They'll have my
records of the from the court of the. It is Additional Deputy Commissioner GAB now. Stroke District Sessions Judge, Clear East Jante Hills. Matter to be listed after receipt of the records.
Obliged.
In fact, when this ex parte judgment was passed, at that time the judiciary was not separated.
Yes, I noted that.
And
that's why I said the ADMG and stroke DSG. So don't do confusion.
And I tried to apply for the copy of the divorce suit. They could not find the records. Just for your lordship's information.
That is why it's court apprehended that, because before separation the records might be misplaced. But we need that, at least the records, at least the process. If he had been served, then it's open and shut. If he had not been served, and that is reflected, then maybe he has a case for
served. The problem is, the address in that divorce suit is different, and in the review.
No, but who received it? We can see from there.
And my lord,
address, my lord, whoever is the addressee in the wrong address would have received it, my lord.
I seek liberty also, my lord, because as per my instructions, the jail superintendent, some receipt is there, but this I'm not very sure. But in case it is there, I am liberty to bring it to court. Bring Gurugram, my lord. In case it is there, I may give a liberty to bring on record.
That you can do it. If you get it, then you haven't got it, then I wouldn't seek liberty to bring something that's not in your hand as yet.
My lord. Obliged.
Item number 4.
Yes, Mr. Bora.
Well, I have sent a notice by registered post on 5th February.
Okay, Mr.
I'll be tracking the consignment.
Officer indicates that notice has been issued to sole respondent on 5/2/2024. This is matter after 2 weeks to await service report.
Much obliged.
Yes.
5.
Yes, Mr.
For the state respondent, we'll file the affidavit with the course of. We'll file during the course of day.
You receive copy? I received copy of the affidavit, they fine? No.
We'll file it during the course.
Yes, we for 5 and 7. Already filed as Mr. A. Khan submits as affidavit, we file the course of the date. It's after 2 weeks for the joinder of any. Okay. Yes.
6.
May I please, Your Lordship? Your Lordship will be filing the affidavit in the course of the day, Your Lordship.
Oh, very good. MS and Raji submits that affidavit, we file the course of the day. What about Bijarwa?
We already filed, Your Lordship. I'm for responding 5 and 6.
Just after 2 weeks for joinder of any.
Lordship.
Any agency?
No, Your Lordship.
Yes.
7.
May it please Your Lordship. Your Lordship, in this case, the petitioners had challenged the termination order of.
But it's supposed to file affidavit.
Yes, Your
You
Lordship.
find
We
it.
just received instructions.
What
that
about number 4? Why? Let's see what instructions.
The-
What's the case about? I'm asking her. Yes.
This is the order, Your Lordship. So I think this will. This should be read as perused, Your Lordship.
You've been terminated already?
Yes, Your Lordship.
Or suspended?
No, he was terminated, which is why we
Terminated?
have, yes. So now the,
That means Mr.
by
Sheikh,
the
where's Mr.
managing
Sheikh?
committee.
Call him here. Mr. Sheikh, why you have not come instructions?
Lordship, here one difficulty is that, Lordship.
What difficulty is there?
There is no managing committee. I was of the with what you call the headmaster of the school has signed the Vakalatnama. When later on I asked that, he said that there was no managing committee and the notice is addressed to the
Managing secretary,
committee, Lordship.
managing
So I have to take some instruction. That is why I could not file my Vakalatnama also, Lordship.
Then we'll say that, yes. Where's the impine order?
Annexure 6, Your Lordship.
Next 6 page.
At page 35. Your Lordship.
We'll stay this termination now.
My Lord, I'll just take it through instruction, Lordship, so that if there is a managing committee, I can file
Yeah,
my
state,
power.
view this order
order,
dated.
Your
That's
Lordship.
why you'll state a termination and then you'll be entitled to subsistence allowance until the inquiry is over.
Let him be under suspension till such time.
Mr. Sheikh, if there's
Can I have only two
I'll give you a copy of this.
just take the order.
But you have no instructions, sir.
MST Young England EAG with so and so today has produced an order dated 12 February 2024, which has a 2024 issued by the Director of School Education and Literacy. That is respondent number.
Who? Director is not
Not there.
the secretary is the respondent, number 1, Your Lordship. They have one
Anyway,
He's not
issued by the Director of School Education and Literacy, dated 12 February, so and so. The same being very relevant for the purpose of the case is reproduced its entirety here and below. Stop. As per the order quoted above, it is noted that the respondent number, that is the SEO number 2, has been directed to inquire into the matter and submit a detailed report looking into the reasons on the basis of which the services of the petitioner was terminated. The direction contained in the order also is that the petitioner should be placed under suspension, and until submission required, until we are awaiting the submission of the inquiry report for further orders. Stop. Next paragraph. Mr. S.A. Sheikh, Learned Counsel for Respondent for Manual Committee, submits that at present there's no manual committee, and that his appearance on the earlier occasion was on the basis of the authority given by the principal. Stop, which is in principle. Stop. He submits that he be permitted to. He prays him a lot. He be permitted to obtain necessary instructions and prays for 2 weeks' time. Stop. Have considered the submission of Mr. Sheikh, but however, in view of the order dated 12 February 2024, it is directed in the interim that the petitioner's termination order shall be directed the termination order dated 18/7/2023 be kept in abeyance, and the petitioner be put under suspension from the said date to await the findings of the inquiry which are being conducted by respondent number 2. Needless to add, the subsistence allowance as admissible should be afforded to the petitioner. Yes, a copy of the orders of the order 12 February is taken on board and made part of the record. This matter after 2 weeks.
Your Lordship, if they can supply us also the copy.
Yes.
The copy of. If they can supply also the copy, Your Lordship.
Oh?
Of the order, perhaps. I think this.
The order, she'll give it to you. It's made part of the record. If you apply, you get it.
Item number 8.
So you're a very lucky lawyer. No one gets a stay on termination. You know that? Where's 2 and 3? Who the people 2 and 3? Has affidavit service been filed? You're supposed to file affidavit indicating service on 2 and 3.
Yes, Lordship.
Why is not filed?
Lordship, I have to.
Have to what? Have to file it?
Your Lordship, I'll file it on the next day. I'll file it.
I pray some more time, Your Lordship, to file the affidavit, Your Lordship.
What's the matter about?
The matter was regarding the appointment of the NOCMA. We have challenged the agreement.
Okay. Yeah, Mr. Sorry.
A. Joshi.
Oh, yes, A. Joshi. Mr. Joshi is submitted due to inadvertence the service affidavit as allowed by this court by order 30 dated 31/2024 cannot be filed. He prays for and allowed further 2 weeks time to file the same. MS N. Raji also submits prays that she allowed similar time for affidavit respondent number 1 and that's after 2 weeks. Yes.
9.
I have a query for the respondent. While the last order, my lords had directed us to file an affidavit, I am instructed that the affidavit is ready and it will be filed during the course of the day.
Yes. When is it? Why do you ask such early affidavit?
Because the matter.
Yes.
Because the matter here pertains to regularization of service in lieu of the transfer of the land, and apparently there is no right which is emanating out of any of the documents.
No, Your Lordship.
Mr. A.S. Pandey, Learned Counsel for the Respondent Corporation, submits that the affidavit will be filed in the course of the day. And this is matter after 2 weeks for rejoinder of any.
Much obliged, Your Lordship.
10.
Obliged, Your Lord.
Your Lordship, so far this matter is concerned, the writ petitioner is aggrieved by the fact before this court to the order dated passed by the EC regarding taking up a complaint against the yes, without placing before the Darbar Hima. There is a speaking order by this honorable court on 11th of Jan to the effect that we must hear this those objection raised by the writ petitioner.
Yes.
That will be taken care by the executive committee, and insofar there is an allegation against the respondent number 4 that he has got a personal interest. We also have taken note of that.
Who's number 4?
Number 4 is Mr. PNC. Mr. PNC. And for that reason,
PNCM is
Deputy Chief Executive.
No, but he's not then executive committee.
He is the Deputy Chief Executive.
No, is he part of executive committee hearing this?
Yes, he was hearing this matter.
Okay.
So the writ petitioner was aggrieved by his.
So he has recused.
So I have instructed the executive committee, and the executive committee on the 1st have authorized 2 other executive members. I cannot bring because of paucity of time. 2 other members, Mr. Tabor Pathau and Victor Rani, to hear the complaint. And the other issue regarding preliminary hearing, that also will be taken care by the 2 members.
Yes, Mr. Paul.
There's nothing surviving.
Let it come by way of an affidavit.
Yes. No, what he's saying that you'll hear your complaint, your whatever.
Well, very well. Whatever, I would only pray before your lordships. Whatever comes, even if somebody is recused
right.
let it come by way of an affidavit.
File a short, just come written instructions. That's all. Mr. Vijayakanta submits that pursuant to the order date 11/1/2024, the respondents have taken steps as much as the respondent number 4 against whom allegations have been made, which is no longer part of the executive committee to hear the complaint, and that the objections raised by the petitioner are yet to be
No, there's a direction by this court.
Huh?
There's a direction by this court.
In case they want to proceed, my lords, they would first address my preliminary
exactly. I get the objections. The objections. Yes.
Are
yet to be heard and concluded. Yes, he's directed to place the same by way of written instructions before the next date.
Yes, we are otherwise saying, my lords, that they cannot proceed in the first place.
Yes,
so if they say so, my lords, let it come by way of an affidavit, then I can address.
No, I'll just bring the.
You don't need this. Let them be with instructions.
We'll bring the written instruction.
Second call.
Lordship after a week.
After 1 week.
Only
instructions, not affidavit.
Yes, Lordship.
Second call, item number 1, daily list.
My apology, my lord. I was not aware of the sequence in the matter will be called, my lord. I was in the impression the supplementary will be called first. My lord, with regard to
first. Oh, this is main list.
Main list.
Okay, yes.
My lord, with regard to this instant matter, my lord, here, my lord, we have to verify the claim of the petitioner, my lord, the amount which, because the documents which have been enclosed in the writ petition are all their document, my lord.
We have not. That is why.
My lord, we are looking into this issue, my lord. They are making the calculation, verification
when
of
the
the
affidavit.
My lord, I'll be requiring time first for instruction. How much is the actual amount? Because, my lord, it has happened the past occasion that we have.
When was the work completed? Contract of which year?
15, my lord.
15. Then they have to begin some time.
It appears, my lord.
Yes, MS ARC only submits that as the contractual, as the work.
2020, my lord,
of the work.
The work was
and the bills due to the petitioner are yet to be ascertained fully. So he prays allowed further 2 weeks' time
my lord.
to obtain instructions. Yes, please.
Highly obliged, lordship.
Second call, item number 1, supplementary list.
Where's Deb?
May I please, Your Lordship, he is still in courtroom number 4, Your Lordship. So I'll accept.
See this one last time. Where's Mr. D? He didn't come to court. Mr. D, he didn't come to court. Relaxing at home.
No, Your Lordship, he's still he's having some puja this morning.
Oh, Saraswati Puja, yes. Okay, see this. You will accept notice on contempt. You accept notice because you suppose the demarcation within 45 days only. Nothing great. It's just that it was your own. You offered yourself. You see in the order that we'll do it, and they say you haven't done it. You see that page 11.
Yeah. I'll accept the notice, Your Lordship.
Okay, as heard Mr. L.D. Sangma, Council Petitioner, issue notice. Ms. Andraji accept notice on behalf of the respondent. No further notice required. She please for allowed 2 weeks' time to file affidavit. You complete the inspection. What is it?
Hearing, item 18.
Here I sought little accommodation, Lordship, here. This is, otherwise this case can be
You
disposed.
asked for 14?
Lordship.
When was, who asked for 14? Mr. Hassan?
Hassan, yes, Lordship, on 14, yes, Lordship.
You're ready to matter today?
Lordship, I'm not ready, in fact.
Why? You're busy doing other things.
No, Lordship, I had one matter.
You're not doing any other job. You're a full-time counsel, no?
Yes, Lordship. True,
No
Lordship.
other side business?
No, Lordship.
Then what's the excuse not getting the matter then?
Here it can be disposed in the light of one affidavit, that para.
Yes.
Para 10, Lordship. Now my appointment for the post of MSP was terminated because there was no post created for newly CNRD block, Lordship.
Yes.
So now in para say that so far as the newly created blocks concerned, the MSP, post of MSP is not yet created, Lordship. So my only preference, I am eligible if the post is created and if I may be allowed to participate in the, my candidature may be considered.
Selection, he can take part in the selection process once the
Of
post is
course.
created.
How old are you?
Lordship, 33, Lordship.
You'll still be eligible.
Yes, Lordship, 33.
You are from the other minor tribes.
Yes, Lordship.
Yes, write down. The petitioner here's your prayer.
That is at page, Lordship, 13, Lordship.
Now, because before you were in West Garo Hills.
Yes,
at
Lordship.
MSP.
MSP.
And then now it's cancelled because you're from Southwest Garo Hills.
No, Lordship, because so far as the newly created block is concerned, that post was not there.
Rerapara.
Yes, Lordship.
Post was not.
Before MSP were Damalgiri.
Damalgiri, same Rerapara only, sir, Lordship. Rerapara.
We'll take down, no? The petitioner you appointed temporarily, not you were not appointed.
Yes, Lordship. If my Lord kindly come to that order, Lordship.
Lecture 4.
Annexers.
Sorry. Lecture 5. Temporary
5.
appointed.
Yes, Lordship.
Yes. The writ petitioner was temporarily appointed to the post of MSP, within bracket, multiple service provider. By order dated 15/3/2018 is before this court, being aggrieved with the cancellation or have been aggrieved with the suspension of the appointment which has been, I'm sorry, was temporary appointed. Yes. In which block we have to record that? Where his name is
Nicholas
in
P.
Damalgiri.
Damalgiri.
In Damalgiri. C. And RD block.
This is also called Rerapara, Lordship.
Damalgiri is seen as per the
Yes, Lordship.
So Damalgiri is in RD block, southwest Garu Hills.
This before this court being agreed with the suspension of the appointment
White order which was issued. White order dated
16 March, on the
16
following
March
day, Lordship.
That is the cancellation, 16 March.
16 months suspension.
2018. Stop. It's cancellation, temporary suspension stroke cancellation. Stop. What after that? What else is going to do? In the respondent, it appears by letter dated 5th April 2019. Had in a communication addressed to the writ petitioner set out the reasons that the post of multiple service provider. What about employment departments terminated on ground behavior and misconduct?
My lord, appointment was made on 15 and terminated on 16.
How misconduct? Yes.
That is why, Lordship.
No, that's what is striking the mind of the court.
respondent, it appears by letter dated 5th April 2019 had in communication addressed to the petitioner set out the reasons that the post of
the termination the termination of the appointment the termination of the petitioner had been necessitated as the post of multiple service provider bracket MSP had not been created for what is one RERA para RERA PRA CNRD block even after a lapse of 6 months from the set appointment order. Stop. In the same letter, it has also been indicated that the employment, the petitioner's employment, should terminated on grounds of misbehavior, misconduct. Stop. Mr. S.A. the counsel petitioner submits that the reason for cancellation of appointment cannot be said is not illegal but only irregular, inasmuch as it is a fact that the post of MSP has not been created for a Paras RD block. However, with regard to the second observation that the writ petitioner's appointment was terminated on grounds of misbehavior, misconduct, the learned counsel submits that this is impossible, inasmuch as the appointments were issued on 15 2018, and the suspension of the employment was on 16 March 2018 itself. He therefore praised that in the event, and as evidenced by the affidavit, that the post is in the process of being created, the writ petitioner would be satisfied if his candidature is considered favorably against the said post. Next, Mr. H. Abraham, Learned Counsel for the respondent number 3, has referred to the affidavit filed on behalf of said respondent, and has submitted that whenever the post of MSP is created for a newly created CNRD block, a due selection process has to be followed. A due selection process be followed for such appointment. And therefore, as and when the said post is created, the petitioner, if eligible, will be considered against the post. Next paragraph. Considering the submissions made, considering the materials record submissions made by the parties, and the absence of any materials to show that the termination of the services of petitioner as MSP was for any other reason than a non-existence of the post, this petition is disposed of with the direction that as and when the post-MS authorities find that, because having injuries, doing training, and a pre-existing condition are two different things.
21.
Your Lordship, please, Your Lordship. This is a case for family pension. Here the petitioner husband, he was the BSF head constable, Lordship. He retired on 1985, Lordship, from his post. And thereafter he was receiving pension. Then, after the death of his first wife, he married the petitioner, Lordship. 16/9/2000.
He retired in 85.
Yes, Lordship.
Then his first wife died.
Then first wife
then
died.
2004. At what age he retired? His constable retired at what age?
Because he took VRS, Lordship.
Okay.
VRS. Then 2004 he married to the petitioner.
Okay.
And thereafter the pensioner, that petitioner husband died on 23rd August 2020, Lordship. Now in the counter affidavit, it is not denied that I am not
the legally
entitled
valid
for
wife.
family
Okay.
pension, Lordship. The only thing they are saying that need some proof, documents. And so far as document, I have enclosed the marriage certificate, Lordship. Then the EPIC, Lordship, where my husband's name has shown, as well as the death certificate of the pensioner, Lordship. In the death certificate also, my name was shown as the wife of the pensioner, Lordship. And apart from that, and if my Lord kindly come to the counter if it is filed by the respondent, Lordship.
Which para?
Para will be page 5, Lordship. J. May I read, Lordship? That further it is also apprised that the petitioner, LS second wife, is claiming the benefits of family pension in the event of the death of the retiree and his first wife, whereas it is a matter of verification about the death of that and his first wife.
Only that part.
And so far as the date I have enclosed the death certificate and his first wife, Lordship, because and I was not supposed to get the copy of the death certificate of the first wife because I was not aware also. Unless or until or unless it is not provided that ex-sender and his first wife are both expired, the claiming regarding the grant of family pension to the less second wife cannot be entertained. Now, so far as the death certificate of the pension I have provided, Lordship. And so far that whether I am a wife or not, I have enclosed 3 documents.
Where's the document? Okay, where's that's a rejection? Only that you cannot prove the death of the pensioner and of the first wife.
Now I have put up one application, the respondent saying that they have not received any documents from my side, Lordship.
Which document? Annexure 1 is
That
this?
Annexure 3, Lordship.
Annexure 1
is
is
14.
ID card.
14 is that marriage certificate, Lordship. Page 14. Page 14 is the marriage certificate.
Yes.
14 is the marriage certificate showing the date of marriage and the details of my husband and myself also. Next page is EPIC, Lordship. EPIC,
yes.
Goenu and Sadindra.
And that certificate is here.
And next page, Lordship, the death certificate. In the death certificates, the name of husband or wife, Koyani Marak.
Now, and even in intimation of that, Annexure 6, it shows that cell application for record death certificate for recruits also, marriage certificate, French, everything. Why then you're granting the pension?
What we
Is the
said,
first wife still drawing the pension, family pension then? But she died before him.
My lord, there is no proof of death of the first wife, my lord. Because as per rules, the first wife is recorded in the service. Her name is recorded.
First claim. Right.
My lord, in our affidavit, we have given the table, my lord, at page 3.
Yes.
Why did you get a death certificate of the wife, the first wife?
My lord, kindly appreciate. Suppose if my husband married to X, and X died, and I am the Y lordship. Now, when she died, and how can I obtain the death certificate of the husband, first wife of my husband, lordship? And she died long back, lordship.
And not only wife, my lord, first wife, my lord, there are children from first wife.
Children, they are major, lordship. If my lord see the age of the nominees, lordship.
The youngest daughter is not become major till now, and daughter is entitled till marriage. So there are other aspects of this also, my lord.
1985.
No, 83 is the last one born. 83 now she's 40 years old.
85.
83. As per the chart.
83, yes, lordship.
Then? Now he's saying regarding the death of ex-Havildar Constable Sennas has not been received by anyone's family members. How do you resolve such cases?
You can get a successor certificate and submit, my lord. I think that will resolve the problem.
You do that, yes. Yes, this writ petitioner.
Again, there will be another problem with regard to the succession certificate. They
The
will ask
objection
the amount.
to the...
Not objection, lordship. So far as the objection is concerned, they will ask for the amounts. What is the amount left behind?
You will supply the amounts. We'll direct
Amounts,
that.
I don't think that there will be any amounts, lordship, because she was, my husband was with me only. Now, so far as to get the pension, because obviously the court counsel will ask for the amount, succession certificate.
No, what is the, when did your husband die?
Died in 2020, lordship.
2020. So, and 2020 now, so they will, what was he, what is the family pension due?
Then if they can, yes, lordship,
Yeah,
almost
all.
4 years, then accordingly I can.
Yes, the
Then it
brief
will be
facts
easy
of the
for me
case
to-
are that the petitioner, who stated to be the wife of a retired BSF head constable, since deceased, has been, sorry, the brief facts. Has been not granted family pension by the respondents.
State also party.
In spite of her claim that she is eligible. Stop. From the facts as placed, it appears that the pensioner, one Sedindra Sangma, Sedindra Sangma, had died on 23/8/2020, and that his first wife had predeceased him. So the petitioner being the second wife. No, up to the deceased stop. In this view, circumstances, in this view, the petitioner, who as stated earlier, second wife, is the wife of the deceased pensioner, so in this view, the petitioner was the second wife of the deceased pensioner. I'm sorry, so it is submitted, that's also the vice also, in spite of supplying all the required documents, the respondents, where's the rejection order?
They have not rejected, Lordship.
The respondents have not processed or granted the family pension as claim. The council therefore prays that appropriate directions be issued, directing the respondents to process and release the claim of family pension of the petitioner's term. Next paragraph. Dr. N. Mozikala, DSGI, on behalf of the respondent submits that as the deceased pensioner had earlier been married to one Meera Rani Sangma, who the petitioner claims has since deceased. I'm sorry.
Dr. Emuska, on behalf of the respondent, submits that as the deceased pensioner had earlier been married to one Meera Rani Sangma, who the petitioner claimed has since deceased.
Who though the petitioner's claim since deceased, however, has not filed any document.
Page 5, para K, my lord. That is our main contention.
Page 5, para K. Here, I think.
Affidavit, my lord.
Where's para K?
Capital K, my lord. Page 5.
Yeah, affidavit.
My lord.
How about Dr. N. Mozika? Dr. Score it out. I submitted that since the petitioner is claiming family pension, the same can only be released if the death of the retiree and his first wife and the remarriage with the petitioner are proved. He submits that as no evidence has been provided showing the death of the first wife, the family pension at this stage cannot be released to the petitioner. So, next para, having heard the counsel for the parties, also seen a material from record, it is seen that the writ petitioner has provided details to respondents such as what do you give them?
We are saying that we never received any such document.
These ones. He says he has given. I'm just saying.
Yes. The dispute.
That has annexed the certificate of marriage, the death certificate of the deceased pensioner, as also the EPIC card, wherein the name of the petitioner is with the name of the deceased pensioner shown as her husband. Further other documents also have been annexed to the writ petition to support the claim. It is noted, however, that though the claim seems bona fide, the absence of any document showing the death of the first wife has resulted in the family pension not being granted to the petitioner. Therefore, in this view of the matter, it would be expedient it would be in the interest of justice if the petitioner be directed to approach the competent court to obtain a succession certificate for the retirement benefits, etc., including family pension, which are due. The respondents are directed to provide unnecessary information as to regard to the amount, extent, and family pension payable to enable the petitioner to undertake necessary action, to file the necessary application. So, with the above directions, the application stands disposed of. Yes.
Any direction so that they can provide me the details after
Already
that I
given.
can- The time within time frame, so that longer time maybe, so that I can.
It is expected that the respondents will supply whatever details expeditiously. Yes.
Item 22.
This is a case where I have challenged a notification issued by the JCDC, my lord, as regard to the election of the Doloi. Lord, that notification is at page number 14. And a type copy is at page number 15. my lord.
1 second, what is this? Notification that? At?
Type copy is at page number 15, my lord.
Yes.
It says, my lord, it is to be informed herewith that the Executive Committee Zenty Hills Autonomous District Council Zoai has decided to hold election of Doloi Ilaka Rimbai as per the dates given below. Now, when this notification was published, my lord, this notification was open to all without providing any restriction as regard to the clan and as regard to the faith of the people who will be allowed to contest as a Doloi, my lord. And therefore, my lord, this instant writ petition was filed, and this honorable court, my lord, has wide order dated 19/5/2023, my lord, has stayed the said impugned notification, my lord. Now, my lord, as far as the post of Doloi is concerned, my lord, and similar such cases has already travelled before the Honourable Supreme Court, wherein the Honourable Supreme Court has already decided that the post of Doloi, my lord, it holds both, it has to perform both.
No, you come first. Okay, the state, who are eligible clans to contest here?
My lord, eligible clans are, my lord, I have already
As per
provided.
custom?
As per the custom, my lord, there are 3 eligible clans, my lord. These are Lingdo, Nongtudu, and
As
Swear.
per the act.
As per the act.
Where's the act?
But I've given a
Oh, this
compilation
one?
earlier.
Oh, competitions here. Okay, okay. Escorlingdo, Nongtudu,
And Swear, my lord.
Okay. So you say that since even though the clans are not named there, but by operation of the act, it is understood that it will be limited to those. Then?
That is the stand of the JHDC.
But then if you see these are 3 clans, okay.
Yes. Now, my lord, as far as the post of Doloi is concerned, my lord, the Doloi has to perform both religious and as well as administrative duties, my lord. And in similar one of such cases, my lord, which went to the Honorable Supreme Court, wherein, my lord, Honorable Supreme Court has decided that, my lord, may kindly have a look at this.
See, you have to show that he's performing those duties which, you know,
Yes,
a person
my lord.
who has converted cannot perform.
Yes.
That's the only thing. If
Yes.
that is the case, then, you know, then...
Now, my lord, I
yes.
have already mentioned in my petition, there are many rituals
Where is that?
and religious duties that has to be performed by the Doloi. It is in my petition, my lord. From paragraph 3 onwards, my lord. I'll just read out, my lord. That a Doloi in the Ilaka Rimbai discharges both administrative as well as religious
Where is
duties.
that para?
Paragraph 3, my lord.
Yes.
That the Doloi in the Ilaka Rimbai discharges administrative as well as religious duties attached to its office. That to perform the Knya Rinkau rituals, Doloi is the main person as the head of the Ilaka to initiate the rituals such as to convey the meeting among all members of the rise and perform the rituals together with the lingdo of the rise. The Doloi has to participate during the Knya Rinkau rituals such as the Ka Sut Kasor as the first step of the rituals which is to be performed in presence of all other key members of the rise. That after the ritual is performed, it is followed by Kasad Niyam Paste Rinkau. That Kasad Niyam Paste Rinkau begins with two key persons of the rise, the Doloi and the Lingdo, and then it is followed by others called Soniam, where members of the rise participates, including the mother and children of the rise. That the Sad Paste is an important war dance of the Panar people. In this dance form, only the male takes part carrying their sword and still dancing to the beat of the war drums and ghungroos. The Doloi leads the dance, followed by the Lingdo and the remaining dancer. Now, that next paragraph, my lord, that these rituals has been performed successfully till the year 1985 by the Doloi, who was from the indigenous.
Okay, one thing you say.
Yes.
Now you say that there was you know, a lot of protest by the people regarding non-performance ritual of Doloi. Is that documented anyway?
Right, my lord. I have already filed my rejoinder affidavit to the affidavit filed by
Was
the.
documented anyway that the Doloi, the earlier Doloi who was Christian, did not perform. He refused to perform.
My lord, we have
and so
filed
the rituals were all disrupted.
Yes.
And so, you know,
Yes,
where's
my
the
lord.
where's
My
the,
lord,
where's
kindly
the
come to my
complaint?
rejoinder affidavit. I filed against the affidavit filed by the respondent number 4.
I get affidavit page. Affidavit file. Huh? You filed a miscase?
And, no, my lord, this is the rejoinder affidavit. I filed against the affidavit filed by respondent number 4, my lord.
Yes.
If my lord will come to page number 18. Typed copy is at page number 20, my lord.
Yes.
Here, my lord, I will just read out, my lord. We, the undersigned for the Dorbar Rangad and others, we request an appeal upon the subject as stated below. As per the notifications of the Dorbar Ilaka, the District Council, JD Joai, it has been announced to the general public that the election of Doloi will be held in place of late Yengswer, who died recently this year, in the year 1971, my lord. In the Dorbar Ilaka, we from the Rangad village, we have informed that whoever hold the post of Doloi has to perform his religious duty along with the Lingdo of Rangad, and he has to be from the indigenous faith. As per religious practice in the Ilaka Rimbai, Doloi is the head of the administration and he is also the custodian of the religious practices. The Rangad village is the village that falls under the Rimbai Ilaka. The religious practice paste has to be organized by the Lingdo with the Doloi Ilaka Rimbai. These rituals begins with Pirna, local wine, which has to be given by the Doloi Rimbai. In the rituals of the paste, the Lingdo of Rangat village has to pin the flower in the turban of Doloi. The salubon is collected and received from the outside of Jaintia. Those were the religious practices of Doloi Ilaka Rimbai, who has to perform religious duties, and he must be from indigenous faith only, non-Christians. And whoever converted to Christian faith, he shall not be allowed to be a candidate for the election of Doloi Ilaka Rimbai. As mentioned above, it is the truth. We have practiced this since olden times till now. After being elected as Doloi, if he converted to any other religion, it is against our religious practice within our Ilaka Rimbai, likewise in Ilaka Joai and other Ilakas. As youngs were Doloi Rimbai who had expired and whom we respected the most, he took part and participated in our religious rite till he hold the last year of his office due to illness and relinquished his indigenous faith without informing us, and we did not know how much it hurt our sentiments and it was against our custom. On the above noted reasons, we, for the purpose of preserving our customs and religious rites within our village and Ilaka, we kindly request you to enquire and scrutinize the qualifications of the candidate before electing the Doloi of the candidate in Ilaka Rimbai, to announce whoever wanted to contest for the post of Doloi Ilaka, Doloi election, Ilaka Rimbai, he shall belong to indigenous faith. A person who converted from indigenous faith to Christian faith shall not be qualified to contest for the post of Doloi. That the district council should reject the claim of the Dorbar Ilaka where they have claimed that a Doloi does not have a religious duties. This is in the year 1971. It was filed. Again, my lord, if my lord will come to the next page number 22.
Seen that, yes.
Type copy is at page number 24.
No, this is not the same one. This is 22 is inquiry officer.
No, my lord, if my lord will see.
Annexure 2, page 22.
My lord,
is customary practice pertaining to the appointment and of the law of Rumbai Leka.
Yes.
Inquiry officer must appear in the revenue officer district council July. Present inquiry in Rumbai village on the 8th of December 72 and 25th January 73. And 24 is annexure.
Objection, my lord.
Is a different. It's not the same annexure.
No. Yes, my lord. Different annexure. 24.
It's not a type copy of this
yes,
one.
Yes, my lord. 24, my lord.
The why is seeing the type copy?
My lord, that is not type copy. My lord, that is my.
There's a difference. Right. It's the data
that
dated
is,
14.
That is inquiry report. If my lord will come to the inquiry report also, my lord will see. After 1971, objection was filed, my lord. Inquiry was conducted by the JHDC, and what the inquiry report said, my lord. As many as 11 headmen and 3 lingdo of Rimbai Ilaka were examined, and their evidence recorded and submitted as annexure from page number 1 to 17 below. That is page number 22, my lord. Summing up of the opinion and informations as recorded in the memorandum, the following facts transpires and corroborated by a majority present.
Okay, fine. This we've seen, therefore, so, and they say that which constitutes a majority Christian which deprived simply on the ground of the religion.
Page number 23, my lord.
That has been dealt with by Ivan Lanki. So anyway, now what's this 24?
24, my lord, this is again an objection, my lord, which was filed in the year 2014, my lord. This is another objection. Relevant paragraph, my lord, I will read out. That is paragraph 9, page number 25, my lord.
Yes.
That, sir, it is deeply regret to state that the last 2 Doloi of the Ilaka was belonged to the Christian faith, and this incident happened due to the fact that people are ignorance of the rule of law. Besides, they are too poor to address their grievances in the proper forum to challenge these incidents of violence of their tradition and customary practice by the Ilaka since time immemorial. And since the custom itself do not allow people from different faith to contest the election to the post of Doloi, except those specifically mentioned, family can belong to the indigenous faith. As such, we pray your good office to cancel the notifications program so issued by the district council for election to the post of Doloi Ilaka Rimbai, and a fresh notification may be issued after taking into consideration the very fact of the tradition, custom, uses followed by the people of the Ilaka. This is the complaint, my lord, which was filed in the year 2014 again. My lord, time and again the complaints were filed, and my lord, again, if my lord will see page number 27, these are the customary practices, my lord, which I have enclosed. The rituals which are to be performed by the Doloi, and the type copies at page number 32 onwards, my lord.
Yeah.
Now, from, if we see, my lord, the annexure which has been enclosed as page number 27 onwards, my lord, these are the customary practices which has to be followed by the doloi and which has to be performed by the, some rituals have to be performed by the doloi. Now, in such circumstances, when a person from other faith, now as far as custom practices are concerned, my lord, traditions are concerned, these are passed on from generation to generation. It is not something that we go to a university and when we learn and then we are fit to do those rituals or perform those duties. These are the things, my lord, which we learn belonging to a particular group or belonging to a particular community. And these are passed on from generation to generation, and therefore, it is very much important that a person who performs these duties, religious duties, my lord, must belong to that particular group. Unless and until, my lord, the person belong to the said group, you will not have the proper knowledge to perform those rituals, and therefore, my lord, this is a very...
Not that also. It's a question of different. Suppose you have converted, now you see, you have cast away, your religion does not allow you to do it. So simple. That's why, from what I can see here, is that in 85 something, the other said, I don't want to do it, I'll send someone else to do
that
it.
Is very, that is
what is
that
the
is,
case from here.
That is very true, my lord.
That is the only thing. So that's the thing. So whether the office, it really is intrinsic, to the office that, he performs both secular and religious duties of administration.
Right.
And, to perform pujas of that particular elaka. If that cannot be separated, if the office means that the office includes both secular and and religious duties, if that cannot be, there's no question of being two dolois.
Right.
That was decided in the case. There cannot be a doloi niyam and a doloi, administration.
Administrative head.
There cannot be two dolois.
Right,
so whether this office of doloi in this particular eleka, it only, he has to perform the duties. It is incumbent upon him, and also he has both secular and other functions, secular and religious functions. So if that is the purpose, then the judgment will apply.
Right, my lord.
But if it's shown that no, that it has not been. But anyway, we'll get the other side. So that's the only thing. If the office cannot be, the office is one.
Right.
That's the thing.
The office here, my lord, it is one office, and the same person has to perform both the duties, my lord.
Yeah, they cannot, because in the Joai case, they tried to put up a case that there can be a doloi niyam and a doloi, but there cannot be two dolois.
Right, my lord. Now, if we see the Act of the District Council, my lord, if my lord has a copy of it, my lord, that is the Jaintia Hills Autonomous District Establishment of Ilaka, Village and Election Appointment Power and Functions of Jurisdiction. Wahesnong Act 2015.
Yeah, we have that Act. This has been supplied by Mr. Council, yes.
Now, if we see, my lord, this Act, if we come to the definitions, my lord, Section 2.
Yes.
Section 2, it says, subsection 3, my lord, customary functionaries means lingdo or pator or sangot or basan or any others who are appointed as such by the doloi and his dorbar according to custom and recognized as such by the executive committee. This is the customary functionary. Now, these customary functionaries, my lord, and doloi is the head of the. Now, if my lord will come to the next, that doloi definition is at page number subsection 6, my lord. Doloi or Siddhar means a traditional customary chief of the Ilaka elected as such under the provisions of this Act. He is the customary chief, my lord.
Of course, yes. There's no quarrel about that. Only thing is that, see, the nature's duties.
Yes.
You see, in other, there are some other doloiships like Narpo, I think, whatever. I don't know. They where, whether they observe or whether they, they still have these traditional, these.
I'm coming to all those.
That's all. That's kind of. So if you see this office is, it is one. It cannot be in any way occupied by a person who's unable to perform these duties, then yes.
Yes. Now, my lord, if
they can show that no, irrespective of he might be a Christian also, but if it does not affect his functioning or the office, he can discharge office without discharging his duties, then we have to decide.
Now,
we have
here
to look
is the case,
at
my lord. Here the same person has to perform both the duties. Now, in the same section, my lord, section 2, subsection 20, my lord, the definition of puja land. This is the act of the district council, my lord. Puja land, what it says, means a revenue-free land held and cultivated by a doloi,
Yes.
sardar, or any of the customary functionaries, and the yield or income therefrom is utilized for meeting the expenses connected with religious performance according to custom of the ilaka.
Yes.
This is the act which it is saying, my lord. Now, subsection 24, my lord, it says service land means a revenue-free land held and cultivated by the doloi, sardar, or by any customary functionary of the ilaka as remuneration for the service rendered by him to the ilaka. Now, section 4, my lord, election of doloi, section 4, clause 1.
Yes.
It says, whenever a vacancy occurs in the office of a doloi, sardar of any ilaka specified in appendix 1, the executive committee, subject to the provisions of this act and the rules made thereunder, shall call upon the concerned ilaka to elect a doloi sardar in accordance with the existing custom and traditions prevailing in that ilaka, and such elections shall be conducted by the returning officer to be appointed and empowered by the executive committee in this matter. Now, the act, section 4, clause 1, it clearly says his elect a doloi, my lord, it has to be in accordance with the existing custom and traditions, my lord. Now, as far as existing custom and tradition is concerned, my lord, doloi here performs both religious as well as administrative duties. And my lord, in my petition itself, my lord, I have mentioned many of the rituals which has to be performed by a doloi, my lord. And more than that also, my lord, I have also mentioned regarding the customary practices, that is at page number 32, which my lord may kindly have a look at it.
32 of?
32 of the same rejoinder affidavit, my lord.
Can you provide pictures of the rituals?
If my lord allows me some time, I'll try to get a copy.
That's all right, yes.
Yes.
If they have, any,
yes.
If you want to say that. But the thing is that all these pujas are done every year.
Right.
But were they stopped at a certain time when the doloi who's a Christian, was it suspended because the doloi was a Christian?
My lord, what has happened is...
No, just answer the question. Now, okay, fine, series are going on. But was it suspended due to the fact that the doloi was a Christian at any point of time?
My lord, till the year 1985,
was
my
it
lord.
Suspended, Dr. Moiska, at any
In
point
the
of time?
affidavit, what you said, my lord, that though at page 5, my lord, of our affidavit, we have said, insofar as the religious and ritual functions of doloi is concerned, the Act 2015 is silent. And as per the prevailing customary practice prevailing in Rimbai Elaka, the Lingdo has been performing the religious functions and the doloi is in charge with the administrative functions only.
Where's the affidavit? But is that as per customary practice? I mean, was it prevalent right from before Lingdo conducted the religious functions?
My lord, may kindly see the
My lord,
inquiry report, which
my
is
lord,
there.
what could be traced, my lord, if lordship kindly turns to page 5, my lord, my affidavit. Respond number 2, my lord. Affidavit of respond number 2.
Yes. Barcelona, Bowman.
Yes, ma'am.
Yes.
But till 1975, we don't. It appears that only the indigenous faith was only on 27 to 1975, my lord. That was one occasion. 93 was one occasion, my lord.
Yeah.
And then 2014. So these are the three occasions, my lord.
Okay. Yes. Who's appearing for? What do you have to say?
My stand is the same as the district.
No. I mean, that's the council first.
Well, our stand, my lord, I'll just point out a few paragraphs in the affidavit, my lord.
Yes.
What we have said basically, my lord, that after
I want to make more detailed arguments. Because this matter has a bearing, on the entire Elika, that kind of things.
It can be heard later. 18 can be appointed. But the matter...
the court has to be fully satisfied also, yes.
But this requires a proper...
Because you see, if you seek to distinguish the judgment, because we are bound by some court judgment, if the facts surrounding the entire case are similar and, paramateria or, like maybe like substantially identical, then we are bound. I mean, we have, but if you can distinguish that, no, like, in such a situation where why, a non-Christian lawyer or what do you call it, any belong to another faith. Apart from
I don't really see anything which can be distinguished as such, my lord.
But I can, my lord. In my understanding, it can be distinguished. Firstly, my lord, that is with respect to 1959 Act and only with respect to Joa Ilaka. The entire judgment talks only about Joa Ilaka. In that particular matter, what had happened is, my lord, the district council had classified and made a classifications amongst the religion, my lord. So that action of the district council was challenged, and that was not interfered with. In this particular case,
that amounts to no. See, one thing, Mr. Nomri, you must understand. The interim order was passed on what? That notification is totally vague. It didn't mention the clans. It didn't mention, what, there's nothing. Yes. It's just as if you rung upon notice. This is an election notification. It should be clear as who are the clients eligible. Like the Joai one was clear. That's why it could be challenged on that ground. Now you should have clarified. Well, they did there also. They didn't do that. It's totally vague.
Very correct, but the Act provides for it, my lord. The election cannot be beyond the Act.
My lord, for this at this stage, my lord, we may argue the matter finally, my lord, at some other date.
Yes, argument because the court also
yes, my lord. We'll come with some more material, my lord. My friend can also come with some more material. What I was praying, my lord, in the interim, enacting the law is appointed, maybe in line with what petitioner is asking for, my lord. If that was
the matter is going to be finally heard. We'll post it next week.
Yes, my lord.
After 2 weeks, but I will keep it part heard.
Yes, my lord.
Since already heard the petitioner.
But hearing may, what I was praying, my lord, hearing may take some time, my lord.
My lord. Time, of course.
And if interim is appointed in terms...
if you just keep a free date, Dr. Mercy, we'll finish it off.
Well, acting could be appointed from the indigenous faith, my lord.
Why? Because you don't have money to
till the matter.
That's the only consideration.
That cannot be a
constitutional authority.
Stop the villages also.
No, administrator has been What's that administrator be appointed with district council?
Yes.
Now, their only consideration is that we can't pay an administrator.
That cannot be a ground.
Can it be a ground? Constitutional authority is saying we have no money.
There are various functions under the Act, of the Deloitte Board, where he has to conduct inquiry and everything.
Administrator does
holding certificates.
everything.
These issues.
Mr. Nomri, everything is after administrator. He steps to his shoes. He's just like, when, like president's rule. They don't want to do it because they say you don't have the money to appoint an administrator to do it.
I'm saying our villages are having problems.
We'll finish it off since you waited for so long.
Or Lordship considers, my lord, we can appoint from
that, my lord, I have
from indigenous faith, my lord, for the time being.
No, we leave it like that. We don't create another,
It's a matter of only 1 week.
We want to start the third party rights. Again, some other people will come, not Mr. Philemon's client, some other people from other villages will say we don't want him. Then people say we don't want him. We don't want that.
Yes.
Yes, this is matter for further hearing on?
Monday, my lord. Next Monday.
This Monday?
Yeah.
Monday is what? 18th?
19th.
19th.
19th board case?
20th? 20th?
20th.
Obliged.
Heard in part hearing, part heard. Heard in part, this is a matter for further hearing on? 20th, yes.
Obliged.
Now, the only concern the court is distinguish, and that I think Mr. Somebody's got the point, that to distinguish, the binding judgment, whether it binds or not, and whether there are other factors which have to take consideration where you can distinguish. That's the only thing. If that is...
that is specific to...
Issued, my lord, when the Act under Section 8 provides what is the eligibility of the Deloitte.
That decision is specific to Joai because Joai was the issue there, my lord.
Whatever it is.
They cannot do something which cannot directly, indirectly, my lord, the same thing.
Satisfy the court.
My lord.
Yes.